It's not being presented for any improper purpose, like harassment or delay. 2. The legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or establishing new law. 3. The factual contentions have evidentiary support or, if specifically identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. 4. Denials of factual contentions are warranted on the evidence or are reasonably based on belief or a lack of information. Violations can lead to sanctions, including monetary penalties or non-monetary directives imposed on the attorney, the firm, or the party. Rule 11 promotes professionalism and discourages frivolous filings.
Okay, so we have the initial pleadings sorted, but lawsuits, as you said, are rarely simple one-on-one affairs. Often you need to bring in multiple players or assert multiple claims. This is where the joinder rules really come into play, right? Along with that huge phase we call discovery. How do these rules help manage complexity?
You're absolutely right. The federal rules provide a framework for managing complexity through joinder of parties and joinder of claims. These rules aim for efficiency by resolving related disputes in a single action, where possible, while still protecting fairness. First, a quick note on capacity to sue and be sued, Rule 17. Minors or incompetent persons must sue or be sued through a representative like a guardian. For partnerships and other unincorporated associations, their capacity is determined by the law of the state where the court sits, except that they can sue or be sued in their common name if the claim arises under federal law. Remember our earlier discussion. For diversity citizenship, you look at all partners members, but for capacity or venue, the rules might differ.
Okay, capacity first. Now, how do you add multiple plaintiffs or defendants to a case from the start?
That's permissive joinder under Rule 20. Multiple persons can join as plaintiffs or be joined as defendants in one action if 1. Their claims or the claims against them arise out of the same transaction occurrence or series of transactions or occurrences, and 2. There is at least one question of law or fact common to all plaintiffs or all defendants. However, you must still satisfy subject matter jurisdiction requirements. Remember Section 1367B. In diversity cases, supplemental jurisdiction generally cannot be used by plaintiffs to overcome a lack of complete diversity when joining additional defendants under Rule 20. But supplemental jurisdiction can potentially be used to cover claims by permissively joined plaintiffs who don't meet the amount in controversy requirement, as long as at least one plaintiff does meet it and complete diversity is maintained between all plaintiffs and all defendants. It's a vital distinction for exam scenarios.
So permissive joinder needs the same transaction and a common question, plus SMJ. What if someone isn't joined, but maybe they should be?
That brings us to compulsory joinder, or required parties, under Rule 19. This is one of the most complex joinder rules, and definitely ripe for essay questions. It involves a 3-step analysis. Step 1. Is the absent person a required party? Under Rule 19A, an absentee is required if A. The court can't grant complete relief among the existing parties without them, or B. The absentee claims an interest relating to the subject matter, and joining them is necessary to protect that interest or to prevent existing parties from facing multiple or inconsistent obligations. Step 2. If they are required, is joinder feasible? Joinder is feasible only if A. The court can assert personal jurisdiction over the absentee, and B. Joining the absentee will not destroy subject matter jurisdiction, only break complete diversity, and C. Joining them won't make venue improper. Step 3. If joinder is not feasible, must the action be dismissed? This is the Rule 19B indispensable party analysis. The court must decide, based on equity and good conscience, whether the action should proceed without the absentee or be dismissed. Factors include prejudice to the absentee or existing parties, whether prejudice can be lessened by protective measures, whether a judgment rendered without the absentee would be adequate, and whether the plaintiff has an adequate remedy if the action is dismissed. For example, can they sue in state court? Dismissal is a last resort, only if the party is truly indispensable.
That's a heavy analysis for required parties. What about someone who wasn't named initially, but they want to jump into the lawsuit because they have an interest?
That's intervention under Rule 24. It allows a non-party, the intervener, to join an ongoing lawsuit. There are 2 types. Intervention as of right, Rule 24A. A non-party has a right to intervene if 1. A federal statute confers an unconditional right, or 2. They claim an interest relating to the property or transaction that's the subject of the action. Disposition of the action may practically impair or impede their ability to protect that interest, and their interest is not adequately represented by the existing parties. The motion must be timely. Permissive intervention, Rule 24B. The court has discretion to permit intervention if 1. A federal statute confers a conditional right, Or 2, the intervener's claim or defense shares a common question of law or fact with the main action. The court considers whether intervention will unduly delay or prejudice the existing parties. Again, the motion must be timely. Timeliness is always a factor, judged by circumstances like how long the intervener knew their interest was threatened, prejudice to existing parties, etc., and importantly for subject matter jurisdiction. An intervener must generally establish independent SMJ, example, diversity or federal question, for their claim. Supplemental jurisdiction usually does not cover claims by or against interveners if the original case is based solely on diversity, especially if intervention would destroy complete diversity.
Okay, intervention lets outsiders jump in. What if you're stuck in the middle? Like you're holding property, say, an insurance payout, and multiple people are claiming they're entitled to it. How do you avoid getting sued by everyone separately?
That's the perfect scenario for interpleader. It's a procedural device that allows a person holding property, the stakeholder, who faces potential multiple inconsistent claims to that property, the stake, to force all the potential claimants into a single lawsuit to resolve who's entitled to the property. It protects the stakeholder from multiple liabilities. In federal court, there are two types: rule interpleader under FRCP 22 and statutory interpleader under 28 U.S.C. Section 1335. Statutory interpleader generally has much lower roadblocks, making it more useful. SMJ, rule interpleader, needs regular SMJ, complete diversity between stakeholder and claimants plus $75K or a federal question. Statutory interpleader only requires minimal diversity between any two claimants, plus the amount in controversy need only be $500 or more, much easier to meet. Personal jurisdiction. Rule interpleader requires the court to have normal PJ over the claimants. Statutory interpleader allows for nationwide service of process, meaning PJ can be established over claimants anywhere in the U.S. venue. Rule interpleader follows the general venue rules. Statutory interpleader allows venue in any district where any claimant resides. Because of these relaxed requirements, statutory interpleader is often the preferred route if its conditions can be met.
Nationwide PJ and minimal diversity. Statutory interpleader sounds powerful. Okay, beyond adding parties, how do parties already in the suit add more claims against each other? Like, can a plaintiff sue a defendant for multiple unrelated things? Can a defendant sue the plaintiff back?
Yes, the rules also govern joinder of claims. Permissive joinder of claims, Rule 18A, this is very broad. A party asserting a claim, original claim, counterclaim, cross-claim, third-party claim, may join, as independent or alternative claims, as many claims as it has against an opposing party. They don't even have to be related. However, you still need subject matter jurisdiction over each joined claim. For diversity, a single plaintiff can aggregate all claims against a single defendant to meet the amount in controversy. For federal question cases, non-federal claims can be joined only if diversity jurisdiction exists for them, or if supplemental jurisdiction applies, meaning they arise from the same common nucleus of operative fact as the federal claim.
Okay, Rule 18 lets you pile on claims. What about claims back against an opponent? Counterclaims.
Right. Counterclaims, Rule 13, are claims asserted against an opposing party. For example, defendant against plaintiff. There are two types, and the distinction is critical. Compulsory counterclaims, Rule 13A. These are claims that 1. Exist at the time of serving the pleading, and 2. Arise out of the same transaction or occurrence that is the subject matter of the opposing party's claim. These claims must be asserted in the current lawsuit, or they are waived and cannot be brought in a later suit. Because they arise from the same transaction, they automatically fall into the court's supplemental jurisdiction, so they don't need an independent basis for SMJ, like meeting the $75K amount. This is a highly tested concept. Permissive counterclaims, Rule 13B. These are any counterclaims that are not compulsory, i.e., they don't arise from the same transaction or occurrence. A party may assert these, but isn't required to. Because they are unrelated, permissive counterclaims must have their own independent basis for subject matter jurisdiction, federal question, or diversity, including meeting the amount in controversy.
Compulsory, same transaction, must bring supplemental jurisdiction. Permissive, if in transaction, optional, needs independent SMJ. Got it. What about claims between parties on the same side, like one defendant against another defendant?
Those are cross-claims, Rule 13G. A party may assert a claim against a co-party, surety defendant A against defendant B, only if the cross-claim arises out of the same transaction or occurrence as the original action or counterclaim therein, or relates to property that's the subject of the original action. Cross-claims are always permissive, never required, because they must be related to the main action. They usually fall under supplemental jurisdiction. Personal jurisdiction is typically not an issue since the co-parties are already before the court. Venue objections are also usually unavailable for cross-claims.
Okay, cross-claims are between co-parties and must be related. What about bringing in a completely new party who might be liable for the defendant's liability, like an insurance company or a joint tortfeasor?
That's third-party practice, also known as impleader under Rule 14. This allows a defending party, who becomes the third-party plaintiff, to serve a summons and complaint on a non-party, the third-party defendant, or TPD, who is or may be liable to the defending party for all or part of the plaintiff's original claim against them. Think indemnity or contribution claims. Defendant is sued by plaintiff. Defendant says, if I'm liable to plaintiff, it's actually TPD's fault, and TPD should pay me back. Impleader can be done without court leave if filed within 14 days after serving the original answer. Otherwise, court permission is needed. For SMJ, the defendant's impleader claim against the TPD usually falls under supplemental jurisdiction, since it arises from the liability asserted in the main claim. However, remember Section 1367B, if the original suit is based only on diversity, any claims asserted by the original plaintiff directly against the impleaded TPD must have an independent basis for SMJ, diversity, or federal question, if asserting them would destroy complete diversity. Personal jurisdiction must also be established over the TPD. The bulge rule might help here.
Impleader brings in someone potentially liable to the defendant. That covers most joinder. What about the biggest scale of joining parties, class actions?
Right. Class actions under Rule 23 are the ultimate joinder device, allowing one or more named representatives to sue or be sued on behalf of a large group, the class, of similarly situated individuals. To certify a class action, 4 initial requirements under Rule 23A must all be met, often remembered by the acronym NCCATA-T. 1. Numerosity. The class must be so numerous that joinder of all individual members is impracticable. 2. Commonality. There must be questions of law or fact common to the class. 3. Typicality. The claims or defenses of the named class representatives must be typical of the claims or defenses of the entire class. 4. Adequacy. The named representatives must fairly and adequately protect the interests of the absent class members. In addition to NCCAT, the proposed class must also fit into one of the types of class actions described in Rule 23B.
NCCAT, how does subject matter jurisdiction work for class actions? Do all unnamed members have to be diverse or meet the amount?
For subject matter jurisdiction and diversity-based class actions, the rules are a bit different. Under standard diversity, Section 1332, the Supreme Court held you only need to look at the citizenship of the named class representatives. As long as they are completely diverse from the defendants, that requirement is met. For the amount in controversy, the traditional rule was that each class member had to satisfy the 75 KK requirement, but the court later held, and supplemental jurisdiction, Section 1367, now generally allows jurisdiction as long as the named representatives are diverse and at least one named representative satisfies the amount in controversy requirement. However, remember the Class Action Fairness Act, CAFA. For many large multi-state class actions, CAFA provides an alternative basis for SMJ with much lower hurdles. Only minimal diversity, any class member diverse from any defendant, an aggregate amount in controversy for the class exceeding $5 million, and generally at least 100 class members. CAFA makes it much easier to get large class actions into federal court.
CAFA helps for big cases. What about ending a class action?
Any settlement, voluntary dismissal, or compromise of the claims in a certified class action requires court approval under Rule 23E. The court must find the proposed resolution is fair, reasonable, and adequate after providing notice to the class members and holding a hearing. A valid final judgment binds all class members who did not opt out if opting out was permitted for that type of class action.
Okay, that's a whirlwind tour of joining parties and claims. Once everyone's in the suit and the initial claims and defenses are set, the next massive phase begins, finding out what actually happened.
That's discovery, right?
Exactly. Pre-trial procedure and discovery is the critical phase where parties gather information relevant to the claims and defenses in the lawsuit. The federal rules provide for broad discovery to ensure cases are decided on merits, not by surprise. There's a general discovery timeline. It often starts with the parties holding a mandatory Rule 26 conference to discuss the case and develop a proposed discovery plan. Then come mandatory initial disclosures, followed by the main period of discovery using various tools, then expert disclosures, pre-trial disclosures, and finally, trial. Mandatory disclosures. You have to reveal things without being asked.
Yes, Rule 26A requires several types of mandatory disclosures without waiting for a discovery request. 1. Initial disclosures. Due usually within 14 days after the Rule 26F conference, parties must provide names, contact info of individuals likely to have discoverable information supporting their claims or defenses, copies or descriptions of documents ESI supporting their claims or defenses, a computation of damages claimed and supporting materials, and any relevant insurance agreements. 2. Expert witnesses. Due at least 90 days before trial, or as ordered. Parties must disclose the identity of any expert witness they may use at trial and provide a detailed written report prepared and signed by the expert, containing their opinions, basis, data used, qualifications, compensation, and prior testimony. For experts not providing a written report, the disclosure must state the subject matter and a summary of facts opinions. 3. Pre-trial disclosures. Due at least 30 days before trial. Parties must provide lists of witnesses they expect to call, witnesses they might call if needed, witnesses whose testimony will be presented by deposition, and documents exhibits they expect to offer or might offer if needed.
Okay, mandatory disclosures give a baseline. What's the general scope of what you can ask for in discovery, and are there limits?
The discovery scope and limits are defined in Rule 26B. The basic scope is very broad. Parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. Relevancy is construed broadly. Information doesn't need to be admissible evidence itself to be discoverable, as long as it appears reasonably calculated to lead to the discovery of admissible evidence. Proportionality considers factors like the importance of the issues, amount in controversy, parties' resources, importance of the discovery in resolving issues, and whether the burden outweighs the likely benefit. The main limits are privilege and work product. Privileged communications, like attorney-client, doctor-patient, spousal, are absolutely not discoverable. Which privilege rules apply depends. Federal common law governs privilege for federal question claims, while state law governs privilege for diversity or supplemental jurisdiction claims, per Federal Rule of Evidence 501. The work product rule, Rule 26b-3, is incredibly important and frequently tested. It protects documents and tangible things that are prepared in anticipation of litigation, or for trial by or for another party or its representative, like an attorney. This material is discoverable only if the requesting party shows 1. They have a substantial need for the material to prepare their case, and 2. They cannot obtain the substantial equivalent by other means without undue hardship.
So work product is harder to get than just relevant info. Is anything absolutely protected?
Yes. Even if substantial need and undue hardship are shown, the court must protect against disclosure of the mental impressions, conclusions, opinions, or legal theories of a party's attorney or other representative concerning the litigation. This is often called opinion work product and gets near absolute protection. Think of internal strategy memos, notes on witness interviews reflecting the lawyer's thoughts that core strategic thinking is shielded.
Work product protects trial prep materials, especially the lawyer's thoughts. How does this apply to experts? Can you discover everything they worked on?
Discovery regarding experts has specific rules under Rule 26b-4. You can depose any expert whose opinions may be presented at trial. Their detailed written reports are discoverable as part of mandatory disclosures. However, drafts of expert reports and most communications between the party's attorney and the testifying expert are generally protected as work product. The main exceptions are communications relating to the expert's compensation, or identifying facts data provided by the attorney that the expert considered, or identifying assumptions provided by the attorney that the expert relied upon. Experts retained only for consulting, who are not expected to testify at trial, are generally shielded from discovery absent a showing of exceptional circumstances, where it's impracticable to obtain facts or opinions on the same subject by other means.
Okay, privilege and work product are key limits. Can a party ask the court to limit discovery if it's getting out of hand?
Yes, through a protective order under Rule 26C. For good cause shown, a court can issue an order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. This could include ordering that discovery not be had, limiting the scope, specifying terms like time or place, sealing depositions, or protecting trade secrets.
You mentioned a Rule 26F discovery conference. What happens there?
The Rule 26 conference is a mandatory meeting or series of communications that the parties must hold, usually at least 21 days before the court's scheduling conference or order. They must discuss the nature and basis of their claims defenses, possibilities for settling, make or arrange for the initial disclosures, discuss issues about preserving discoverable information, especially ESI, and develop a proposed discovery plan outlining timing, subjects, limits, and ESI issues. This plan is then submitted to the court.
So they plan out discovery. What are the actual tools or methods they use to get information from each other?
There are several primary discovery devices. 1. Deposition, Rules 3031. Oral or written examination of any person, party or non-party, under oath, recorded stenographically or by video. Crucial for getting witness testimony before trial. Limits generally apply. Example, 10 depositions per side, 7 hours per deposition. Non-parties must be subpoenaed. A subpoena ducis tecum compels a non-party to bring documents to the deposition. 2. Interrogatories, Rule 33. Written questions directed only to another party, limited to 25 questions, including discrete subparts, unless stipulated or court-ordered. Answers are written under oath and usually due within 30 days. Good for getting specific factual information or identifying relevant documents witnesses. 3. Request for production or inspection, Rule 34. Written requests directed only to another party asking them to produce documents, electronically stored information, ESI, or tangible things for inspection and copying, or to permit entry onto land for inspection. No presumptive limit on number. Response usually due within 30 days. Essential for obtaining documentary evidence. Non-parties can be compelled to produce documents via subpoena under Rule 45. 4. Request for admission, Rule 36. Written requests asking another party to admit the truth of certain facts, the application of law to fact, or the genuineness of documents. No limit on number. Response due within 30 days. If admitted, or not denied objected to properly, the matter is conclusively established for the purpose of the pending action. Powerful tool for narrowing issues for trial. 5. Physical or mental examination, Rule 35. Can only be ordered against a party or person in their custody control when their physical or mental condition is in controversy and upon a showing of good cause. Requires a court order or agreement of the parties. Less common. Used mainly in personal injury cases.
Okay, depositions, interrogatories, document requests, requests for admission, exams, lots of tools. How can this discovery information actually be used at trial?
Discovery serves multiple purposes, including use at trial. Depositions can be used to impeach a witness, show inconsistency with prior testimony. An adverse party's deposition can be used by an opponent for any purpose. It's an opposing party's statement. Can also be used substantively if the witness is unavailable at trial, JDT, dead, beyond subpoena power, 100 miles away, ill, etc. Interrogatory responses, admissible against the party who made them as an opposing party's statement.